Welcome everyone, and today we're going to delve into a crucial piece of legislation that protects us all. The Republic Act 7877, also known as the Anti-Sexual Harassment Act of 1995. 7877 was a landmark legislation that recognized the need for specific law against sexual harassment. It aims to protect individuals from this harmful behavior, promote a safe and respectful work environment, and ensure the victims have recourse. Section 1. Section 1 is the title. This act shall be known as the Anti-Sexual Harassment Act of 1995. This act aims to protect individuals from sexual harassment, promoting a safe and respectful environment in workplaces, educational institutions, and training programs. The law emphasizes the importance of dignity and equality, recognizing sexual harassment as a form of discrimination. Section 2, Declaration of Policy. The state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Section 3. Work, education, or training-related sexual harassment. Work-related sexual harassment. The sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in granting said individual favorable compensation, terms, conditions, promotions, or privileges, or the refusal to grant the sexual favor results in limiting, segregating, or classifying the employee which in any way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. The above acts would impair the employee's rights or privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. The above acts would impair the employee's rights or privileges under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee. Education or training-related sexual harassment. When the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice. Any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another without which it would not have been committed, shall also be held liable under this act. Sexual harassment may take place in the premises of the workplace or office, or in the school or training institution, in any place where the parties were found as a result of work or education or training responsibilities or relations, at work or education or training related social functions, while on official business outside the office or school or training institution, or during work or school or training related travel, at official conferences, fora, symposia, or training sessions, or by the telephone, cellular phone, fax machine, or the electronic mail. Illustrative forms of sexual harassment are the physical, verbal, and others. So the examples of physical are the malicious touching, overt sexual advances, gestures with lewd insinuation. Of verbal are requests or demands for sexual favors, lurid remarks, and others. The use of objects, pictures or graphics, letters or writing notes with sexual underpinnings. So there are classification of sexual harassment. The grave offenses. It is the unwanted touching of private parts of the body, like genitalia, buttocks, and breast. The sexual assault. The malicious touching, requesting for sexual favor in exchange for employment, promotion, local or foreign travels, favorable working conditions or assignments, a passing grade, the granting of honors or scholarship, or the grant of benefits payments of a stipend or allowance, and other analogous cases. Less grave offenses: unwanted touching or brushing against the victim's body, pinching not falling under grave offenses, derogatory or degrading remarks, or innuendos directed toward the members of one sex or one's sexual orientation or used to describe a person, verbal abuse with sexual overtones, and other analogous cases. Offenses: surreptitiously looking or staring a look of a person's private part or worn undergarments, telling sexist or smutty jokes or sending this through text, electronic mail, or other similar means, causing embarrassment or offense, and carried out after the offender has been advised that they are offensive or embarrassing, or even without such advice when they are by their nature clearly embarrassing, offensive, or vulgar. Malicious leering or ogling. The display of sexually offensive pictures, materials, or graffiti. The unwelcome inquiries or comments about a person's sex life. The unwelcome sexual flirtation, advances, propositions, making offensive hand or body gestures at an employee, persistent unwanted attention with sexual overtones, unwelcome phone calls with sexual overtones, causing discomfort, embarrassment, offense, or insult to the receiver, and other analogous cases. Section 4. The duties of the employer. Promulgate appropriate rules and regulations in consultation with and jointly approved by the employees or students or trainees through the duly designated representatives, prescribing the procedure for the investigation of sexual harassment cases and the administrative sanctions therefore. Administrative sanctions shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. Employer. Create a committee on decorum and investigation of cases on sexual harassment. The committee shall conduct meetings as the case may be, with officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. It shall also conduct an investigation of alleged cases constituting sexual harassment. The contents of the complaint. The full name and address of the complainant. The full name, address, and position of the respondent. A brief statement of the relevant facts. Evidence in support of the complainant, if any. A certification of non-forum shopping. 5. Liabilities. The employer or head of office, educational, or training institution shall be solidarily liable for damages arising from the acts of sexual harassment committed in the employment, education, or training environment if the employer or head of office, educational, or training institution is informed of such acts by the offended party and no immediate action is taken thereon.
Next is Section 6, Independent Action for Damages. Nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. The offended party may take independent action for damages incurred in the act of sexual harassment. She or he may also avail of relief. 7. Penalties. Any person who violates the provision of this act shall, upon conviction, be penalized by imprisonment of not less than 1 month nor more than 6 months. or a fine of not less than 10,000 pesos, nor more than 20,000 pesos, such fine and imprisonment at discretion of court. Any action arising from the violation of the provision of this act shall prescribe in 3 years. Action 8. Separability Clause. If any portion or any provision of this act is declared void or unconditional, the remaining portion or provisions hereof shall not be offended by such declaration. Section 9. Repealing Clause. All laws, decrees, orders, rules, and regulations, other issuances, or parts thereof inconsistent with the provision of this act are hereby repealed or modified accordingly. Section 10. Effectively Clause. This act shall take effect 15 days after its complete publication in at least 2 national newspapers of general circulation. Before I end my discussion, I would like to share some awareness, and let's have a recap about our topic, which is all about Anti-Sexual Harassment Act of 1997 or Republic Act of 7877. There is some question that I would like to answer in order for you to expand your ideas about this topic. So first, what is sexual harassment? It is the act of defending, requesting, requiring sexual people from another, whether accepted or not, by a person who has authority, influence, or moral ascendancy in a workplace, educational, and training environment. Second, where is sexual harassment under Republic Act of 7877 is committed? From that definition, it is committed in the workplace, educational, or training environment. Third, when can there be a sexual harassment? There can be a sexual harassment when the offender and offended party are related to each other as employer or employee, teacher to student, and trainer to trainee, or other setup where a person has the authority, influence, or moral ascendancy. Lastly, who will violate RA 7877? A person, female or male, may violate RA 7877 by directly performing the prohibited act or by inducing directly another person to commit it, or by cooperating in the commission of the prohibited act. Without such cooperation, it would not have been committed.
Republic Act 7877 is a powerful tool for creating a safer and more just society. Let's all work together to ensure that everyone feels safe and respected in their workplaces and communities. Thank you. Bye bye.